Hey guys, welcome to this video. This is John Watts. I'm a consumer protection lawyer. We're going to look at an FDCPA, Fair Debt Collection Practices Act case, but not so much on the FDCPA. This particular case, which came out July 30, Northern District of Ohio, involves some debt collectors suing a consumer, getting a judgment against that consumer, and then the consumer sues the debt collectors for FDCPA violations and asks that the state court judgment be sort of tossed out by the federal judge. And so we'll look at a doctrine called the Rooker Feldman Doctrine and Collateral Attack Doctrine. And I think that you'll find this interesting if you either are a lawyer or a consumer and you're dealing with saying, okay, well, there's a judgment against me in state court. Can I go to federal court and sue those debt collectors for what they did in state court? So the background is there's a summary judgment in favor of the debt collectors against the consumer appeals, and then the consumer sues. And this is really the substance of it. The consumer files a lawsuit seeking damages and wants the defendants to pay fines. The consumer also asks that the court vacate, which means to get rid of, the state court judgment, and order the debt collectors to issue a written apology for damaging and sullying the consumer's family name. Well, the defendants say, hey, judge, you don't have jurisdiction, subject matter jurisdiction. Remember, personal jurisdiction is power over the person. Subject matter jurisdiction is power over the subject of the lawsuit. And so the judge spends some time going over subject matter jurisdiction. And I'll put a link to this decision so you can read this, but we'll jump right in to this thing called the Rooker Feldman Doctrine. So what is that? It says that precludes or prevents lower federal courts from exercising jurisdiction over actions that in substance seek appellate review of state court judgments, even if the plaintiff claims the state court judgment violates federal rights. So if something happens in Alabama Circuit Court and I don't like it, I could appeal it to the Alabama Supreme Court. Or I might say, well, let me go to federal court and convince that federal judge to undo what the state court judge did. And sometimes I might ask directly for that, and we'll see that in the next doctrine. But sometimes I ask the court to kind of, in essence, do that. And the various circuits of federal courts view this all a little bit differently. So let's see what this judge says. It says the lower federal courts cannot review final state court judgments because that power only exists in the United States Supreme Court. So to challenge a state court decision, litigants must proceed through the state appellate system and then to the Supreme Court of the United States. So normally you go all the way to the Supreme Court of the state, and then after that, you go to the U.S. Supreme Court. But this isn't sort of all-encompassing here. It has a limited scope. It applies only to the narrow set of cases brought by state court losers complaining of injuries caused by state court judgments rendered before the district court proceedings commenced and inviting the district court to review and reject those judgments. So the court has to say, well, let's look at the source of the injury. If it's the state court judgment itself, then the Rooker Feldman applies. But if the injury flows from a different source, then this is an independent claim, and the Rooker Feldman Doctrine would not prevent this. So the judge says, I don't think the Rooker Feldman Doctrine applies because the plaintiff's saying, I was injured under the FDCPA, Fair Debt Collection Practices Act, independent of the state court judgment. And the judge says, well, look, I have subject matter jurisdiction over the FDCPA, and nothing takes away my power, my jurisdiction, just because the consumer never raised the FDCPA arguments before the state court. And because this is an independent claim, I can't use Rooker Feldman to get rid of this case, even if it's that FDCPA issue is really tightly intertwined with the state court judgment. So the correct way to argue this is preclusion. So we call this sometimes claims preclusion, issue preclusion. And that says, hey, look, I already won this in state court, so you can't relitigate this in federal court. But Rooker Feldman is not the proper way to do this. And it's interesting what the judge says here. It says, look, these debt collectors are just really upset because this FDCPA issue should have been raised in the state court action. And that gets rid of judicial efficiency by bringing it up in federal court, squanders scarce resources. And the court says, I agree with you. But the Sixth Circuit has said, while other doctrines like res judicata, collateral estoppel, forfeiture can discourage strategic sandbagging in litigation, Rooker Feldman's focus lies elsewhere. So the defendants do not win on that basis. But what about this collateral attack? And here the judge says, well, look, we have to look at the Constitution. It says that we have to give state court judgment the same preclusive effect as would be given that judgment under the law of the state in which the judgment was entered. So we don't like situations where one court is attacking the authority of another court. Now, they're not talking about like an appellate court. And the defendant says, hey, this is an impermissible collateral attack on what the Ohio court did because the plaintiff is trying to undo the judgment. And the plaintiff, the consumer, says, no. All I'm doing is suing you for unlawful debt collection practices. And apparently the substance of this was they gave 4 different amounts owed, and the consumer saying that's illegal to misrepresent the amount owed, which is a very good point. And so the court says, I got to go with the debt collectors here. Despite the plaintiff saying she's not raising a collateral attack, she does say that state court action itself was in violation, and she asked the judge to vacate and stay the state court judgment, which you don't get that type of authority under the FDCPA. And then we have the plaintiff says you can't collect the debt because it was time barred, and that goes to the validity or collectability of the debt, which is the state court judgment. And so the judge says because the core of the attack is on that state court judgment, it has to be dismissed. And you need to pursue your appeal, which you have. But you're free to file a federal complaint challenging the legality of the debt collection practices. And so the judge ends it with saying, really all you're doing is attacking the debt. Okay, and this is an important concept. And sometimes we get this confused. Just because the FDCPA has been violated does not mean the debt is invalid. Okay, so there could be a perfectly valid debt, and the debt collector calls all my neighbors, and they put a billboard up, says John Watts owes all this money, and they just flagrantly violate the FDCPA. Well, I still owe the debt, okay, but I have a claim against them. So just because I can sue a debt collector doesn't mean the validity of the debt goes away. And the validity of the debt was established in state court. And that's where it has to be finished, is in state court. Now, if I'm saying, regardless of whether it's valid or not, the debt collector violated the FDCPA, for example, in this case, apparently giving 4 different amounts, which would mean they're misrepresenting the amount owed, now that's fine to do that. So that's why I wanted you to see this case. There's a little bit other stuff about changing the venue, but really this is a good case to read, to find out about that Rooker Feldman, and to see the plaintiff, and she did a good job here of sort of avoiding that Rooker Feldman. Now she was caught by that collateral attack issue, and it makes sense. You just can't go into federal court and say, hey, you go write an order that state court judge was wrong. And look, we use this when we're sued in state court and we win that case, and then we sue the debt collector and say we never owed the debt. Oh, they always want to relitigate it in federal court. And when I say sue in federal court, usually we sue in state court, it gets removed or changed over to federal court. But when they're in front of the federal judge, they say, oh, no, they owed the debt. We'll prove it. And we'd say, Judge, that issue's already been decided in state court. You have to respect that decision. And the judges are very good about that. They're like, yeah, that's an equal judge over there in state court, whether it's small claims judge or, whether it's a $500,000 case in circuit court. It doesn't matter. We have to respect that opinion. So hope you found this helpful. And if you like this, let me know, and I'll do more of these case opinions. And feel free to subscribe to our channel, and I'll catch you guys in the next one. Thanks a lot. Bye-bye.